that is unresolved. Okay, good afternoon. This is Judge Elisa Perez presiding over the 210th District Court criminal docket for September 17th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I will go ahead and call the case 2022 0D04319 and 2023 0D04641. State of Texas versus Alexis Carrasco. May I have announcements, please?
Ada Waneri for the state of Texas. Present ready, Your Honor.
Honorable Judge Perez, Fernando Chacon for the defendant, Your Honor, ready.
And Mr. Carrasco is appearing remotely from the downtown jail. Mr. Edas, you're on this case. You were on the probation case, weren't you, Mr. Edas?
Yes, Judge, that is correct. Edgar Edas for the probation department.
And so I'm clear, the 2022 case is set for a probation status hearing. It was in reviewing that and some of the case summary that I saw that 2023 case is still not disposed of. So you are on it, Mr. Chacon. I just wanted to make sure that we weren't leaving anything behind by just addressing the probation status because the UUV doesn't have any settings. So we're going to have to get that one at least set for status, if not for trial.
On the probation case, Your Honor, I believe that the defendant was in jail and then he got taken by the feds. He didn't have a chance to report. And I think that probably the violation is for non-reporting. That's what he tells me.
So Mr. Edas was very diligent. And let me go back. I know I have a case summary, but when I looked it up, actually, Mr. Edas had emailed the court back in 2023 with a very full summary. And I will tell you that when I was looking up the jailings, apparently, maybe that's why he didn't report over in Odessa either, because they had him as not complying with their probation over there. So he was placed on 8 years straight. He went to Odessa without permission. He said he had to go deal with a case over there. They started the transfer process. He did not provide probation with any of the paperwork. Then Mr. Edas got in contact with Ector County, spoke with his probation officer, Andrea Morales, reported he absconded from his probation. Mr. Carrasco was on probation for tampering, picked up an unauthorized use, and thereafter absconded. Then he was picked up, I guess he was served by El Paso PD and was placed on PR bond in Odessa. He had yet to contact his probation officer over there. And then he gives a summary of his compliance. He was dropped from counseling. He was accepted in June of 2023, dropped. He didn't do his class. He failed to report from July. What I have down is all the way to August. So I'm sorry, June 2023 to August 2024. He has an ICE hold. Say that. He has an ICE hold. So there's an immigration detainer. He didn't go test in June. We're talking shortly after he pled, Mr. Chacon. Right after he pled, he's not doing what he needs to do.
But didn't he get picked up in the jail by ICE or by the feds and therefore not have a chance to report?
Mr. Edas, can you give us any insight onto that?
Judge, my understanding is when he was over there in Odessa, he got picked up, I guess, for a warrant that he had from Odessa, and then not really too sure what happened to him. I just noticed that he does have that ICE hold, but I don't have any information on that, or I don't have any information on his whereabouts for the last year.
Yeah. So do you have any information on that, Mr. Chacon?
No, I don't, Judge. I'm going to have to get an investigator for it because it's unclear from the portal. And I like the report that Mr. Edas had to send to me so I can take a look at that and go over it with my client.
Mr. Nanez, will you run me a PSR on Mr. Carrasco so I can see any jailings that he has?
Yes, ma'am.
So, Ms. Waneri, do you have anything for the court?
Your Honor, it doesn't sound like he did anything on probation, so he should be revoked.
Yeah, my first notation was 10 TDC until I went back and I looked at the plea paperwork and I saw that he pled 8 for 8. So The most he can get is 8.
Well, let's say we'd ask for 8 years.
The underlying facts are not good. The underlying facts on the case that he pled to are not good. I don't know if you've had a chance to look at the UUV, but Myrna, we need to put that on a very quick trial track, like a 6-month trial track on the UUV. I did not review that one. I just saw that it was outstanding because he's still being held on that one as well. We've got a lot of cases, and I'd be curious to see the PSR to see how much more he's picked up. I mean, he got what he got.
His new indictment as I don't know if I've got it yet.
You do, you've been appointed on it.
Right.
Mm-hmm.
Okay, so this hearing is for both the indictment and indicted case and
No, the UUV was not set for hearing today. It was in looking over his probation case that I saw he still had an outstanding case and that you were appointed. Actually, you were appointed on March 17th, 2023. So I don't know why we didn't wrap this up together with the robbery.
I think we should have my recollection is that we asked to get all his cases done, and that would be the procedure that I follow. I wouldn't
That's
live.
what everybody follows, Mr. Chucko, and so why is it still out there? I
Well,
looked at the plea
probably-
paperwork, Mr. Chucko, and I looked at the plea paperwork for that reason, because I thought, well, was this something that just was supposed to be dismissed when he pled? But there was nothing on the plea paperwork that indicated that, and it's been so long. I'll just tell you, I was reviewing that over lunch, so I didn't get much further than that, but that might be it.
Might
I'm not
just be a mistake that we didn't plead him also in that case, because I would have pled everything on that time, and it was 848 for all cases.
Oh, I see what it is. I think, let me look. If I'm looking at the settings, his arraignment wasn't until September of 2023, and by that time he was gone. Yeah, I'm not sure. Maybe you were appointed at the jail magistrate and it just didn't get indicted until like 3 or 4 months later when we had already resolved his robbery case. So the probation case will carry with the UUV. So we need to work that one up and find out where we are, but the court is not going to keep him on probation. So thank you very much. Myrna, if you will please set the new case on a trial track.
Yes, sir.
Okay. All right, anything else? Okay, who's next?
Nothing wrong.
Thank you, Mr. Chucklin. We can take care of Ms. Brown. Annex, do you have Ms. Brown?
Yes, Your Honor, let me get her out.
Thank you. Ms. Bayan, are you there?
Yes, ma'am. Good
Okay,
afternoon.
good afternoon. Have you met with your client recently?
Yes, ma'am, and we've had some jail calls. She's doing fine.
Oh,
Is
good.
that, yes.
Okay,
And my social worker, we've been checking in on her and speaking with her, and she's, if it's a competent, she's fine, Judge.
okay. No, I remember Ms. Brown very much.
Yeah, she's improved. She's doing very well. You'll be very impressed.
Good afternoon, Ms. Brown. How are you?
Hello, how are you doing?
I'm doing well, thank you. We're about to start your hearing, okay?
Sure.
Calling cause numbers 2020-0D02497 and 2020-0D01208. Each case styled the state of Texas versus Elaine Brown. May I have announcements, please?
Ada Winnery for the state of Texas, present ready, Your Honor.
Edith Payan, on behalf of Miss Brown, we are ready.
And Ms. Brown is appearing remotely from the jail annex. We are set for bond hearings in each of these cases. You may proceed, Ms. Bayan.
Thank you, Your Honor. As the court, Hope has in front of the court my pleadings. By way of background, Miss Brown has now been incarcerated continuously as of April 4th, 2022, to a total of 898 days, and I include her time at the El Paso Psychiatric Center. She went to the El Paso Psychiatric Center for competency restoration in March of 2024. It did take some time to get there. I think we were still dealing with COVID, and as the court knows, the list is long. She was there approximately 4 months. She was found restored to competency and was rebooked into the county jail July 19th. So we're just short of another 60 days. Since that time, she has been restored to competency. I do not have any concerns. She has been on her medications. She's been compliant with her medications. With regard to the traditional bond factors, obviously Ms. Brown does not have sufficient means to post the bond. Both these bonds are set at, I believe, $10,000. I'm sorry, $100,000, excuse me, yes. She is not a flight risk, Your Honor. She does have significant ties to El Paso. She has her mother on the Far East Side and on Tierra Lince. She has a daughter. She also has a granddaughter. We would not ask that she return to live with her family. We are asking that she be allowed to be released on PR bond, notwithstanding Senate Bill 6, Your Honor. And I'll get to that, but we have worked with the reentry program and they have accepted her and she would go to the rescue mission. We also have an appointment scheduled with her follow-up appointment with BHN Takumi on September 24th at noon. And she also has a recovery coach with Puntos de Partidas that she would be able to follow up with. And
Does Punto de Partida have like a residential, like some place for them? Not any, I thought they
not that I'm aware of, Judge. I know they work with them and they can go to Puntos de Partidas, but they don't have a place for them to live. I know we're dealing with Senate Bill 6, but I would ask the court, whatever discretion the court may have, or to ask for a surety as low as $1. The indictment that's going to cause the problem is the cause number ending in 1208. That's an aggravated robbery. I know I don't want to litigate the facts, but on the face of the indictment, Your Honor, there is no deadly weapon alleged, and the reason it's an aggravated robbery is because of the age of the complaining witnesses. The complaining witness is over 65, so that's the enhancement in the code. I'd also like to point out to the court and the state, this indictment has been enhanced, but it's not an appropriate or legal enhancement. The underlying offense, the 2019 0D05416 that's used to be enhanced was a state jail, so you can't use the state jail. And on top of that, it was reduced to 1244A, and the time was done in county jail. So in terms of the severity of the punishment being a factor, this is not an enhanceable offense. She does, though, having said that, she does just have that one prior felony, but she's never been to TDCJ. She does have a GED, and we would have to get her relinked with all her benefits and her Social Security and whatever else would be appropriate. She would need to follow up with the Social Security Administration upon release. So for those reasons, Your Honor, given the time in her incarceration and her mental health being so much better and so much more stable now, I'd ask for the court to grant a PR bond, a split bond, a surety bond of $1 on that cause number so that she may be released. Nothing further.
Ms. Winery, well, let me hear your response.
Your Honor, it's difficult when it comes to mental health cases because, you know, the reason why she's doing so well now is because she's been in jail for almost 800 days. She went to a psychiatric hospital. They were able to get her on medication and have her regulated and then be consistent with that medication. If there were some assurances that she could stay consistent, state wouldn't really oppose, right? Because, you know, she's been in there a long time and she is entitled to some sort of relief. But the rescue mission, I don't know that that would be an adequate place for her to go. And I know it's a difficult spot because, you know, what do we do? But I'm just always opposed to someone with mental health being released back on the streets to fend for themselves, You know, I know that defense has said that they have an appointment set up for her on the 24th, but what happens after that? What happens if she's not, you know, able to continue on the medication? What happens if she picks up another case? That's the state's concern, is that she's doing well now because she's been forced to do well. So the state would oppose based on those reasons and those reasons alone, unless defense has some assurances that there will be a safe, steady place for her to go, where her medication will continue to be monitored, and that she will be able to have access to that medication for longer than the 10 days that the jail will provide.
Judge, I honestly don't know how to respond to that. I mean, as the court knows, once we get her to EHN, she'll have her appointments if she needs to walk. The rescue mission isn't that far from 1600 Montana. I don't think it's fair that her mental health issues and her situation where she is essentially homeless is used against her. She obviously, at this point, the rescue mission is a suitable place for her. I'm not sure what the exact concerns are. I don't want to advocate against myself in a future hearing with regard to the Opportunity Center, but as the court knows, I'm not sure if the state knows, but there are some differences, but she is within walking distance. And I mean, there are no other assurances. I mean, depending on how they screen her and what level of services she qualifies for with the EHN, they do have a FACT program where they do go check on them, but I can't speak to that because that's not on my ability to guarantee what level of services they will provide for her. All I could say is that for now, we just need to get her out, get her placed at the rescue mission, get her money. She has worked in the past. I mean, hopefully she could get some kind of job, and maybe when she gets her Social Security going again, we can get her a little apartment, but that's not going to happen unless she's released. So, you know, at that point, we're stuck in a catch-22. I will tell you, I know Miss Brown has been very anxious to get out. She's been very anxious since she was at the psychiatric center. She's been through a lot. She's had a hernia surgery. So she has suffered a lot, and I do think she's ready to get out, but I can't predict the future. Nobody can.
I remember very much Miss Bayan, Miss Brown, and I think at least once pre-trial, I don't know if she made bond or if I ended up fully PRing her, but it did not work. And I really do appreciate the situation, because I know to what extent things can get difficult for Miss Brown. Okay. I have a lot of concerns about letting her out with the plan that is in front of me today. I'm not comfortable being at such a low bond amount with the proposal that you have. So let me ask this. What I don't have a great handle on with respect to her cases is how ready they are to go to trial. Because I have a trial date in 30 days that I can give you.
Your Honor, I would at least like an opportunity to work with the state to see if we can work something out. I would like to not go to trial, seeing as how Miss Brown does have a felony conviction. At that point, we would have to consider possibly going to the court for punishment. I would hope at least that the state could keep an open mind to probation if the court could at least, we haven't had the regular settings since she's been back.
No, I know, but we had done a lot of work
Right.
before she went on the competency.
Right.
But
And
that's
so
what I don't have a full handle on is, for example, you know, as early as October 2020, you know, she had a jury trial.
I would at least, I know the state's been very busy in your court. We've been trying to sit and meet and talk about a list of cases. Miss Brown is on one of them. But like I said, I mean, I'm hopeful we might be able to work something out if the court would like to give us a reset in 30 days, if that works for the state. And if we can't work something out by then we'll know if we're going to go to trial or not. But obviously, Your Honor, notwithstanding the enhancement, it's still a first degree. It's still indicted as an aggravated robbery. She still has a felony conviction. So, I would like to know that I did the best I could to work something out before we start setting things for trial. And I don't want to just waste trial settings.
I agree, but I also, if I can snag one, as quickly as I can, I mean, I'm not trying to pressure you all, but she's certainly somebody that I would give a very high priority to on trial. And so if we're not talking about, so for example, I had October, I think 18th.
That wouldn't work, Judge. I mean, we have most of the records, but we would have to deal with bringing in witnesses from out of town. Bringing in, if we're gonna go to trial, I'd have to bring in, I need psychiatrists, I need psychologists, I need experts. It may be early December.
I have December, Myrna, okay, this is where I need you to stop me if I'm doing something crazy. December 13th. Ooh, I just saw a whole bunch.
I'm checking, Judge.
Okay. Let me see the week before that to see if there's anything that's gonna mess us up. I think there is.
Judge, they're all regular trials and we have one civil case in there. Mr. Kennedy and Sophie,
Mm-hmm.
or actually two civil ones.
December 6th. I'll just tell you right now, Miss Winery, hang on. December 6th is huge.
That's
Yes.
December 6th.
I don't know, but there's a 1,000 cases set for trial on that day. All right. Okay. On the bond, I am going to reduce her bond, but I know, Miss Bayan, there's really nothing so limited in terms of resources. It's going to be a $30,000 split bond, 20,000 cash surety, 10,000 PR, report weekly, comply with all mental health requirements, commit no new offenses. That's as to both cases. Live at the, well, why can't, I mean, don't tell me things that obviously you can't tell me, but the family, she can't live with family? Are they they're not the complainant?
No, it just seems to not be a suitable family right now is not an option. I mean, we could revisit that issue, Judge, and if I'll work with her and I'll have my social worker work with her family, and if that's a possibility, I'll ask the court for another bond hearing.
Mm-hmm.
Thank you. I appreciate that option. And we'll follow up with Ms. Brown for other options that would address the court and the state's concerns, hopefully.
Okay. For now, I am going to put that for December 13th with lead up settings, beginning with a 2801 about 30 days out. So that should give you all an opportunity to have a discussion and then file what you need to file. Okay.
Okay. And I'd just like to throw this out there for the state. If you could offer me some kind of probation, or ideally I would like a lesser, if we could please look at that. I'm going to be forthright. The complainants they're not willing. They don't want to, well, the lady doesn't want to sign a non-pros, but if we could look at a lesser, and that would, keep Ms. Brown accountable for her mental health and put her on mental health caseload. But I know we need to take a good look at that.
Ms. Bayan, in terms, I mean, as you have those discussions, you're, way more than even the court does about all the options. But, with these new mental health courts, things of that nature, I think everything, it's like not leave any stone unturned about the resources because of the delicate nature of Ms. Brown's situation.
Yes, ma'am. Thank you.
Okay, so about 30 days out for a 2801 leading up to that trial setting, and we'll see where we are.
Okay,
If you
thank
need to
you.
Come back on the bond by all means, do. Thank you. Thank you, Ms. Brown. Okay, who's next?
Page 17, Judge. Eileen Reese. And
Mr.
next you have Reese,
Yes, let me get her out.
and I believe Mr. Olivas on Marco Garcia's got the reset, Judge? He
Yes,
didn't have his paperwork?
correct.
He's
That's
coming
good.
back Thursday.
Okay, thank you.
Your Honor, who got reset?
Marcos Garcia, we were missing an item from his attorney.
So we no longer need him?
Correct.
Thank you, Your Honor.
Miss Reese is at the annex?
Yes, Your Honor. Right
Oh,
here.
okay. I think last time she was downtown. Okay. Calling cause numbers 2022-0D04904 and 2022-0D01523, State of Texas versus Eileen Reese. May I have announcements?
Ada Winary for the state of Texas, present ready, Your Honor.
Rick Huffman on behalf of Ms. Ruiz ready.
And Ms. Reese is appearing remotely from the jail annex. This are pre-revocation hearings. I think we were here about 30 days ago. Mr. Huffman, you were gonna look at something, but I think the court was pretty firm that I was at 7 TDC. So what else do you have for the court today?
Well, Miss Bayan is with the Inspire court, and they're still trying to figure out like the parameters, what are the qualifications. So we are still kind of holding out for that possibility, but we do not have an answer whether she meets the guidelines or not. Judge, we were also hoping the court might consider a low number here. She doesn't have any, well, she was arrested recently, Judge, on a jail assault, a fight from.
When did
I
that
think it was
happen?
July. It's a misdemeanor assault. But Judge, other than that misdemeanor assault, she's never had any violent offenses.
So wait a minute. So we're picking up new cases, but you want a lower number? I mean,
Well, the new case is like I said, it seems like a fight. I have not.
no.
Apparently, there's a video of it. They have not uploaded the video. I don't know.
For Inspire, was it the Inspire court? Oh, no, maybe I'm getting my courts mixed up. Is that the one that required a 1622?
I believe so, Judge.
Right. So do we have a diagnosis?
There is a diagnosis, Judge. She's been taking medications in the jail since she's been in, and she's been taking them regularly.
Mhm.
I think her mental health issues are a possible reason why she's self-medicating.
All right. So look, we've already been here. I gave you 30 days last time and we still haven't had any movement. So we're the 17th. Oh, I don't even know if I'll be able to bring you in on the 26th, but we're going to set you for 26. It's going to be a Zoom. So you just that's for you to update me on whether you have another option. If not, Miss Winary, what, I don't know. Then you're gonna have to tell me if you want a contested revo or she wants the 7. Okay,
Understood.
all right. Thank you very much. Thank you, Miss Reese. All right, anyone else?
Judge, that should do it for us.
Thank you, Annex. Thank you very much. Let's get off of YouTube, please. Thank you.